But because, we have decorum at the bar. If you have a professor of law misbehaving at the bar, then there's a problem. I'm urging that you direct that remark be withdrawn first, then we make progress. I'm urging, my lord. The remark was made in your presence. I'm urging it be withdrawn first, then I can respond. Now the paradox, as I got it, because I don't want to make speeches, is that my colleagues accused this side of making speeches, and in the process they made speeches. But having said that, my lord, an issue has arisen following disclosures by my Lord Justice Mrima about how this bench has been constituted. It's now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity to sit, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We urge that you give direction on the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and canvass that application on whether you are properly constituted. Because if it turns out that you are improperly constituted, even the issue of recusal becomes secondary. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if we follow that route, in accordance with my teacher's guidance, Professor Gidu Muigai, there will be greater order and coherence. And I thank you.
My Lord, is that an adjournment? Is that Mr. Ongoya applying for an adjournment? Because he's saying, and perhaps rightly or wrongly, that even the recusal application comes after determination of the question of empanelment. If that be so, and they may leave, they normally leave court, they left Senate, may leave court, we let them say whether they're applying for an adjournment.
Is that remark, they normally leave court, whether they left Senate, my palatable in this court, my lord? I need that.
No, because this is an adjournment.
No, is that remark palatable before my lord and my lady? But because, we have decorum at the bar. If you have a professor of law misbehaving at the bar, then there's a problem. I'm urging that you direct that remark be withdrawn first, then we make progress. I'm urging, my lord. The remark was made in your presence. I'm urging it be withdrawn first, then I can respond.
My lord, I have no problem with withdrawing the remark, but the point is, it is a veiled application for adjournment, because Mr. Ongoya is saying that the court must address the question of empanelment before the recusal. So why can't we just get to the point?
I am answering the question now, but I know that he has withdrawn. He said he has no problem with withdrawing, but I didn't withdraw. I want him to withdraw first, my lord, because I'm entitled to dignity.
Ongoya, I have no problem with withdrawing. You're my friend, but no, I have no problem, my lord. I withdraw the remark, but
so thank you.
There is practice.
Thank you. Let me now address the question as addressed. My lord, Professor Ojienda was my teacher and been my mentor of many years. I have no disrespect for him. I just want my own dignity asserted, because I can't protect my client's dignity if my own is in question. But having said that, my Lord Judge Mrima, you are a witness that the issue of how this bench was empaneled has been disclosed here, when we are here. We have raised concerns through learned colleagues, Kibe Mungai, and learned colleague Mr. Ndegwa.